So the next case is Corpora versus Doran Jason et al.
Thank you, Your Honor. May it please the Court, Andrew Cassier on behalf of the appellants. Your Honors, I think it's not without a touch of irony that this case is being heard in the courtroom because although I was not trial counsel, I would be the first to admit that this was not a model case of pretrial practice on behalf of either the plaintiff or the defendant.
That's the only reason you are going to admit it, because you're not responsible.
Well, I've been known to take responsibility when it's my fault, but...
You'll take responsibility, but no blame.
Right, because people who are responsible keep their jobs and people who are blamed do not. In this case, in April of 2008, the circuit court judge, who I'll refer to circuit court judge as circuit court judge number 1 because there were actually 2 circuit court judges involved in this case. An order was issued by the first circuit court judge for the parties to prepare a joint case management report. It wasn't done. There was some level of blame or carelessness or negligence, I believe, on the part of both attorneys, but who to assign blame to was not the point. The point is that it wasn't done, but defense counsel did not at that time file any kind of motion seeking either sanctions, motions to compel, etc. He does file a motion seeking to strike the pleadings based solely on the failure to file a case management report, but he doesn't file that motion until exactly 1 year later, April 2009. Significantly by that time, several events have occurred. Plaintiff's counsel has now noticed the case for trial. Circuit Court Judge number 2 has now set the case for trial. The case is set for trial in July of 2009.
When was the case filed?
2000. And
Speak up.
2000. It was 2000, Your Honor. And interestingly enough, although the sanctions...
It's 11 years old, right?
Yes, right now the
11
case...
11 years old this year.
This year it's 11 years old.
I mean, it's going to be an adult pretty soon.
Yes. The irony about what happened is that when the motion was finally heard by the Second Circuit Court judge, what was argued that day had very little to do with the failure of the parties to file the case management report a year earlier. Instead, the defense attorney raised issues that were not in his motion and started arguing what the court is concerned with right now, that this case is very old, etc. We're being prejudiced. The defendant...
Your argument is that lawsuits do not have expiration dates, like Wheaties packages and bottles of milk and things like that.
No, I mean, there are procedures within the rules, obviously, to get a case to trial, and certainly I think the problem here is that the court, whether it was done intentionally or not, I think the trial judge was misled into believing that what she was hearing was some kind of motion to dismiss for lack of prosecution, lack of record activity, and in fact the only motion before her was a motion to dismiss.
I mean, it sounds to me like a plaintiff or a plaintiff's counsel didn't much care about a lawsuit, and the judge said, why should I care?
I think to a certain extent that may have happened, and
I mean, if a plaintiff doesn't want to get his or her lawsuit to trial in 10 years, it seems like that there's no interest. Or the judge said, okay, I'll call this off for lack of interest.
right. But the problem, Your Honor, was that at the time that the judge was voicing those very same concerns or opinions, the case was set for trial. Mm-hmm. There was a case management order in place. The plaintiff had already filed a witness and exhibit list. Discovery was pretty much complete. And interestingly enough, the defendants had a pending motion to continue the case. In the only motion that was heard that day by the circuit court judge.
Of course, they could care less if it ever went to trial, as long as they're not having spent a lot of money on it, which they weren't.
But that's true, but it does kind of defeat their argument that they're being prejudiced by the fact that the case is not going to trial.
They're not being prejudiced. They had to open their mail twice a year.
That's my point. They're not being prejudiced.
And that's about it.
Yeah, but
Pretty good deal.
I don't even know if prejudice is the issue. I mean, really looks like plaintiffs dragging their feet, and trial court says, you know what, you didn't comply with the order, because that's what I thought it was about.
Right.
a pretrial order. Is the trial court wrong as a matter of law? Or are you just asking this court for relief?
I don't think the trial court was wrong as a matter of law, but I think what happened was, in applying the law, the facts of the case were not clearly fleshed out before the court, and based upon the facts of the case, I think the wrong decision was reached. This clearly, the only error that was made in this case upon which the motion to strike pleadings was based was a failing of counsel. Clearly a failure to file a case management report or file some other...
Didn't the trial judge find that the plaintiff was himself or herself involved in the delay?
But that's exactly the point, Your Honor. How could a client, how could an individual appellant or an individual party be responsible for the delay in their lawyer filing a case management report?
The problem with what you're doing, you're answering a question with a question.
Okay, then let me answer the question a different way. The findings of the trial court that the plaintiff was personally involved are not supported by the record. The motion to strike was in fact based upon the pleadings, could be based solely on the only ground raised by the defense and the defendants for striking the pleadings, which was the case management report wasn't filed a year ago. But instead, the court in its findings addresses matters relating to alleged discovery violations or dilatory discovery conduct, none of which were ever presented to the court in a motion, none of which defense counsel apprised the plaintiff that he was going to argue that morning. To a certain extent, it was almost an ambush. And unfortunately...
Did you move for rehearing on those grounds?
Yes, we did. The rehearing was denied. As a matter of fact, originally when we had asked for rehearing, the circuit court judge had actually granted us an actual hearing, an oral argument on it, and then we suddenly got a letter in the mail saying that the courts decided to just rule on the pleadings and denied the motion for rehearing.
I mean, there is no evidence, although you'd have to be almost willfully blind, but no evidence, it seems, but no evidence that the client in this case, Mr. Corpora, participated in delaying this case.
That's precisely my point.
And so your argument is, despite the fact that this thing has gone on for far too long, that nevertheless as a matter of law, under a long line of cases that we have, including the Kozel case,
right,
that you don't penalize the client for the lawyer's misdeeds or negligence.
Yes, and Your Honor, in fact, in the Kozel case, I think had the court properly applied the factors and had the defendants properly styled their argument in front of the court to be open and honest about the record, it would have been clear that the only failing was the attorney's failing, and significantly, there's nothing in the record to say that the court ever...
Mr. Cassier, I don't think the word honest is appropriate.
Okay. I'll try it. I apologize for using that word, Your Honor. I will say that had the Kozel factors been properly applied, the court would have had to consider lesser sanctions. And it's clear from the record that at no time were any sanctions considered directly against the attorney, whether in the form of an admonishment, a fine, or even arguably holding him in contempt of court.
And that would have been appealed too. Probably.
But at least the case would have gone forward as scheduled last July. Excuse me, 2 Julys ago, July of 2009. I'd like to reserve some time for rebuttal.
Okay.
May it please the court, I'm Gary Brooks. I represent the appellees, Doran Jason, and the Hojan Corporation. I hope the court will indulge me a moment. I got here early this morning because I wasn't sure I could find this place. I was looking for a place to eat, and then I had to find the law school, and then I had to find this particular room. I must have spoken to at least 10 different students, and without exception, every single one of them pulled their hip-hop music out and was courteous and pleasant and accommodating. I was very impressed by the conduct of the students.
That's because of your hair.
White hair.
They respect their elders.
It's like I said at my 50th high school reunion, Judge, I still got my hair. You understand that. Judge Shepard understands that, at least.
You certainly know how to flatter a panel.
Well, I'm very pleased to say that I think I handled the last case Judge Schwartz had before he went on the bench. I'm not pleased to say I think he won. And I've been coming before him now for as long as he's been on the bench, and he always poses an intellectual challenge, and I'm grateful he's still around. This case is all about the following issue. Did the trial judge abuse her discretion in entering a final judge for the defendant for, quote, blatant, close quote, and, quote, willful, close quote, failure to comply with a court order, here a case management order? I'd like to read briefly from the court's final judgment because it summarizes her position. After spending 2.5 pages reciting how virtually nothing was done in this case by the plaintiff except once a year, clearly to avoid dismissal for lack of prosecution, the court said, quote, "It appears clear from the record that, for the most part, plaintiff did not actively pursue bringing the case to issue and setting it for trial. This aggravates a situation in which plaintiff blatantly ignored a clear mandate of the court to provide her with a case management order within 30 days after her April 23, 2008 order compelling same. Not only did plaintiff fail to do this, but it failed to respond to 3 letters, including a proposed case management order transmitted to it by defendant's counsel. Instead, almost a full year went by when once again the case was in jeopardy of being dismissed for lack of prosecution. This time, plaintiff filed a notice for trial," unquote. That really tells it all, factually speaking. I disagree with opposing counsel that the case management order was in place when the notice for trial was sent out. The case management order was never, that I proposed, was never approved by opposing counsel. We are not at fault. Defendants are not charged with the responsibility of expediting a case. Sometimes plaintiffs file lawsuits when they're angry, and the anger subsides. They say, all right, forget it, it's not worth it. Sometimes they can't afford to go forward. Sometimes they lose interest. There are all sorts of reasons why, as is well known to defense counsel and defendant, that plaintiffs may very well give up on the case.
They didn't in this case.
I don't understand.
Did not do so.
I don't understand it. They took one action a year for 9 years.
But that's what the rules provide, and the cases interpreting the rules say that if you do it within the time that it's provided, that's it.
I agree
There is no
100%.
inherent right of the court to dismiss for lack of prosecution except under the rule.
Yes, sir, I agree wholeheartedly, and I did not move to dismiss for lack of prosecution for that reason, because you're right. I moved to dismiss because of the
But isn't
willful failure.
Essentially, isn't that what happened?
No.
That this is an old case, and it should have been moved, and it wasn't, and
That's
the
what,
only person who is to be sanctioned in some way or another is in such a situation is the plaintiff is. It's the plaintiff's case and doesn't want to move it, and it's dismissed. But there's no provision in the rule or the cases for that being done.
yes, sir. And that is why, if the court had dismissed it on those grounds, it would have been wrong. It dismissed it for the willful and blatant failure to comply with
What
her
is a
order.
blatant failure to comply, as opposed to just not
Blatant,
complying?
I suggest to you, means the court was pretty upset about the fact that this was a 9-year-old case which a plaintiff never prosecuted, as she recited, and that, quote, aggravated, close quote, the situation where they did not comply with the court's order. Then that was aggravated by...
But 2 zeros
Yes, sir.
or 8 zeros are still 0. The fact that if you don't have enough to dismiss for one thing, and you don't have enough to dismiss for another thing, you don't add them together to get something to dismiss.
That may be true, Your Honor, but I do think there is something. The court was upset, not only because of this case that dragged on for 9 years, where...
The court was upset and justifiably upset. But the question is whether the sanction
Yes,
was
Your Honor,
appropriate.
and I agree, and I have to show you that, and I'm going to be doing that. But why the court was upset, and I'm not sure what contumacious means, I've heard it my whole life, I think it means aggravated or terrible, and there was contumacious behavior. Why? Because not only did the plaintiff fail to comply with the case order to prepare a case management order, but then I took it upon myself as a defendant, and I think this court can take judicial notice. Ordinarily, plaintiffs prepare orders of this type. I sent a letter 2 weeks after not receiving anything, expecting to get something. 2 weeks later, in the middle of May, the order was entered April 28th. May 8th, I sent a letter, I believe it was, saying, isn't it incumbent upon you to prepare the case management order for me to review?
Mr. Brooks, when was the answer filed in this case?
The answer was filed in 2008, I believe, Judge.
8 years after the complaint?
Yes, Your Honor. I have to admit I missed that.
You missed that?
I missed the fact that we had a motion to dismiss that had not been heard. I thought the answer had been filed. I even moved for partial summary judgment, and it was granted.
The motion to dismiss that pending for about 7 years and 11 months.
Yes, Your Honor. They
7
did.
years or 11 months.
You know, Judge, I think I liked you better when you were criticizing them for not taking this case forward, but when they had the obligation to do so. I think that's maybe, if that's an underlying issue.
You know,
I'll bet.
If you want to tell all the law firms of Miami.
His hair is gray. Yours is
White. Yes,
pure.
yes, Your Honor. Well, if you want to tell the attorneys in Miami throughout the country that from now on defendants have to expedite getting cases to trial, I suggest that would not be appropriate. We have one obligation as defendants: do not act in a dilatory manner. That's the code of ethics. We can't do things deliberately to delay, but we have no duty to expedite. And
Absolutely.
that,
Everything,
There it is.
every word you say and every characterization you make about the case is accurate.
well, remember.
But you know, we're back to the same thing.
Well, if I may go on why I believe this was contumacious and willful. Not only did they fail to prosecute the case.
But was the letter addressed to counsel or the party?
Yes, the attorney, he got it. He didn't deny he received the letters, 3 letters.
Three
I think that's what bothered the judge. I sent the first letter 2 weeks after I didn't get one, after the court's order saying, you do it, you're the plaintiff. You know, I think I may have said something to the effect, let me know if you don't want to do it. And then a month went by, I sent another letter, essentially the same. I sent you a prior letter, you don't want to do it. Then 1 month after that, I prepared my own case management order. And I sent it to opposing counsel, said, here's my proposal. Please let me know, if it's acceptable. No response. I thought, quite frankly, at that time, that they had finally decided to give up the ghost. That was it. They weren't going to do anything anymore. Then, like the court notes, a year later, suddenly, on the verge of being knocked out for lack of prosecution, they filed a notice for trial. The judge was misled into thinking the case management order had already been entered. It had not been. I think she was pretty upset. And that's what happened here. I would like to point out some things about the law.
So if the case was set for trial, it was improperly set for trial.
Absolutely.
Because there was no case management.
Absolutely. We had discovery that had to be done and other actions. And the judge, the judges, they set these cases for trial. The courts are so overwhelmed. It's incredible, much more than when any of the current appellate judges who are on the bench can understand. I had a trial before Judge Mano Shore. She said she had 10,000 cases right now. So to take time, carve out time on a calendar, put down a case, and then find out later that it wasn't even really ready to be set because no case management order had been entered, I think upset her. I would like to
If
address
you had
some of
filed the motion, if the defendant had filed the motion 3 weeks after the non-response to the third, or to the defense-generated case management order,
I think we wouldn't be here
it would have
today.
been
Absolutely. And I think that Judge Shepard said it all. I believe it appears that plaintiff's counsel didn't care. Quite frankly, I think it's the plaintiff that didn't care. You don't go 9 years with a client who doesn't know what's going on and say that it's really the lawyer's fault. And I would like to address that point. They know that this is defense to the sanctions that were imposed. It was the client. The client was not at fault. I, the lawyer, will take the hit. Fine me, do what you want. But the client is innocent. They could have filed an affidavit. They could have done something. They never even mentioned it in their argument. They didn't mention it below, they didn't mention it on appeal, they didn't mention it in either of their two briefs. I suggest to you respectfully, the reason they didn't mention it is because it isn't true. The client knew what was going on and probably said, look, delay as long as you can for some reason. Maybe he didn't have the money. Maybe the trial lawyer needed money. That's the usual situation where they drag things on. They hope for a settlement or something, but they don't want to go to trial. And, you know, it's not in the record, but I'm suggesting that clearly the plaintiff knew. I would like to address some of the legal issues.
All right, well, your time is almost up, so if you
I
want to address
apologize for
them,
not being
do
able
it
to
quickly. I know you.
The legal issues. Let me suggest to you
Now we'll
this.
talk about the law.
The Kozel, Ham, and Burgess cases deal very strictly with situations where the client may be totally innocent. The language suggests that. It's been distinguished in the Levine case. Here's what I think. There are 3 lines, and I'll conclude with this thought. There are really 3 types of reasoning that have been given in different lines of cases for when the court is justified in dismissing a case when somebody does not comply with the court order. One of them, and Judge Ramirez raised this in the Burgess case, and he was the dissenting vote, but he talks about reasonableness. And that is also true in the Ham decision. The Supreme Court started off by talking about reasonableness. Incidentally, in the Burgess case, the Third District Court of Appeal, this court did not even cite the 6 factors in the Kozel case. It put it in a footnote and referenced it, but didn't go through the six factors. And what I want to do is 2 things, and I'll conclude with that. First, I would point out in the Kozel case at page 818, the Supreme Court concludes that the purpose of the civil rules of procedure is, quote, to encourage the orderly movement of litigation, close quote. And again, quote, the swift administration of justice, close quote. The plaintiff violated this rule. And those factors, even the factors in the Kozel case existed here. The court made a finding of willfulness, and that is, quite frankly, most of the cases on this point only talk about willfulness.
All right, well, you've outlined that in your brief.
Yes, Your Honor. And therefore, let me suggest the following test. You can consider it.
The following is affirmed.
No, I'm going to go further than that, because I would welcome an opinion, because I think there is...
If you had unlimited time, you would, but you
This will
don't.
take, the court will indulge me in an additional minute. There is some ambiguity in 3 lines of cases: reasonableness, the necessity only of willfulness, use of 6 factors. Here's what I suggest the court may want to do. I suggest that the test is or should be that dismissal is justified when a party fails to comply with a court order. If such failure is willful or contumacious, you need to have that in there, absolutely, and involves accompanying aggravating factors, which may include either some or all of the factors enunciated in Kozel, so that the test of reasonableness is
And you
fulfilled.
want, in this opinion, for us to do that and to quote, and to attribute that quotation.
I'm too old to
you.
worry about attribution any longer, Judge.
And to reverse the question what was asked in an earlier case, if it were just per curiam affirmed, you would take that too.
I remember in the last case, or the one before, Judge Shepard pointed out, reasonableness means no other judge would do the same thing. I like that test too, and I think a lot of judges would do this. They're so overwhelmed, overburdened, they won't put up with this stuff anymore, and they should not put up with it. Thank you for your attention.
Thank you very much. Rebuttal?
Just very briefly, Your Honor, I wish to point out that beginning with the motion for rehearing and ending with the appellant's initial brief, we did in fact argue that the party himself, the plaintiff himself, was not to blame for the failure of this court order from April of 2008 to be followed. In my brief at page 14, the third Kozel factor, which is whether the client was personally involved in the act of disobedience, I pointed out that there were no findings made by the court on this factor.
Was there an affidavit? Was there anything that said that? Did the plaintiff show in an affidavit that I didn't know what was going on? I certainly didn't know anything about the obligation concerning the pretrial order. Is it anything?
There was no affidavit from the plaintiff. There was not.
How can a plaintiff who has a case know that nothing is happening in his case for 11 years?
I want to answer the court's question. I don't want to express conjecture and go outside the record.
I asked you to. Go ahead. What's the conceivable explanation?
The conceivable explanation is that for whatever reason, either the plaintiff was trying to see if the matter could settle, whether he had financial resources to progress the case faster. I mean, those are the things that come immediately to mind.
Okay.
And his lawyer did the best job that he could to try to keep the case alive until the case was ultimately set for trial. While there was no affidavit.
But keeping the case alive also involves obeying court orders.
Absolutely. Absolutely, Your Honor. I understand that. And I think unfortunately counsel now understands all too well.
So what sanction would be appropriate, counsel?
You're giving me permission to act as a judge for that question?
Your suggestion.
I think under the circumstances, given that the case was in fact set for trial, and there was at least some evidence in the record indicating that it was more a case of negligence or even gross negligence, but not willful misconduct, I would think that an appropriate remedy would be an admonishment by the court and the imposition of a fine against counsel and the awarding of attorney's fees for having to bring the motion.
And just let the case go on for another 9 years?
No, at that point the case would have gone to trial in July, hopefully notwithstanding the defendant's motion for continuance.
The case should not have been set for trial in the first place.
Well,
The
actually,
case was not right for trial after 11 years or 10 years.
Well, actually, it was. What was not prepared for the First Circuit Court judge was a case management report. At that time, no trial was set. And the case management report, had it been prepared and presented to the court, would have basically advised the court, this is where we are. I don't have to tell Your Honors, but for the benefit of the audience, it would have told the court, these are the things that have been done, this is what still needs to be done, we're in a trial-ready posture. And while that wasn't done, by the time the motion to strike the pleadings was filed 2 weeks after the successor circuit court judge entered a case management order, which was properly entered because the plaintiff had noticed it for trial.
All right, here's a problem that I have. I'm worried about our trial judges. An 11-year-old case, trial judge steps out on a limb and basically throws the case out after 11 years, is obviously from the court order upset, and then we come back and maybe you can help me with this. Reverse, and the trial judge is then scratching her head, and the other trial judges that read this and they say, what are we supposed to do? We get no backing from the appellate court. We do whatever we can to move our cases, and everything we do is wrong. That's what I'm thinking about. Help me out with that.
Well, there are rules and procedures in place, as Judge Schwartz.
There are rules and procedures,
in
and it
place.
looks like the trial court followed the rules. The only thing you're holding hanging your hat on the Cozell case by saying one of the elements of the 6 elements maybe hasn't been met. That's what it seems like.
Well, that's not my entire argument. That's a very fundamental part of my argument, but the fact of the matter is that the court was being asked to rule on a motion to strike pleadings based on failure to comply with a single court order. And it's
right,
clear
well, what's the purpose of court orders if people don't follow them?
That's why there are other sanctions that are appropriate.
Well,
that's why
clearly there are other sanctions too, and the trial court maybe could have done that. Maybe we wouldn't be here. I don't know.
And I think, Your Honor, in all fairness to the plaintiff, I think that's a very big maybe. I mean, I think the
all
case.
fairness to the plaintiff, but an 11-year-old case. I mean, if this were just throwing a name out, Bank of America, or Allstate Insurance, some huge company where things fall through the cracks, but this appears to be not that kind of plaintiff. Maybe I'm wrong.
It's not.
It's not. So you kind of know if you've got a case pending out there. One would, if I did, okay, putting myself in the plaintiff's shoes, I'd be wondering for 11 years what's going on with my case. But all right. Anyhow, I'm just wasting your time at this point. And so if you could bring your argument to a close, please.
Yes, I will, Your Honor. The only other thing I wish to point out is that while the court was being asked to address whether sanctions should be imposed and what sanctions should be imposed for failure to file a case management report, I think it's clear that, unfortunately, what the judge was doing was considering that the case was too old and moving to grant sanctions, the ultimate sanction of dismissal based on the age of the case. And I would point out in the record, Appendix 8, which is the transcript of the proceedings, at page 5, the court said, quote, "The case is 9 years old. If you haven't been able to get it to trial, you're never going to try it." And then in the following page, the court says, quote, "I'm unable to extend this case." And that wasn't the issue before the court, unfortunately. So I would respectfully ask that this court reverse. Thank you, Your Honor.
Thank you very much.